Ladies and gentlemen, Mr. Ombudsman, pleno titulo, distinguished guests, the title of my presentation is far too long, so I have to limit this presentation, and I'm suggesting the subtitle Systemic Competence Framework for Environmental Planning Acts. I will only point out some main issues connecting to the other issues. So the first slide, the first issue, environmental planning acts, hereinafter EPA, form a very extensive structure of related documents in the Polish legal system. All of these acts are the elements of public administration, so they need specific legal grounds for adopting them. And the issue of key importance seems to be the constitutional framework for their adoption. It determines the actions of both the body adopting the planning act and the legislator establishing the statutory framework for these acts. The planning acts, we are talking about such documents as plan, program, strategy, concept, prioritized study, policy, etc., are the basic instruments of state's policy and its formal expression. It's the important issue. Most often they are defined as acts issued by public administration bodies, setting out goals, tasks, directives of action of the addressees, together with the indication of the measures for their implementation. It is so worth noting that, however, these aforementioned tasks, directions, and goals are only a refinement of the category which is original on primary in relation to them, i.e., of course, the value. In other words, planning acts are the acts of various legal form, prospective in nature, issued by public administration, specifying the values to be implemented and the means used to achieve these. The issue affecting the scope of the constitutional provisions relating to the environmental planning acts is the determination of their legal nature. Unfortunately, their legal qualification often leads to divergent conclusions. In my opinion, it is reasonable to say that the assessment of their legal nature cannot be reduced only to recognizing them as the specific legal form of administrative activity. We call it a planning act. More detailed findings are necessary, aimed at classifying these acts within a typical catalogue of administrative activity, especially as normative acts or, for example, administrative acts. The main argument for me determining this is the need to define the scope of control of planning acts, and of course connecting to the title of the presentation, since the Constitution does not refer to the concept of planning act, the implementation of the aim of the presentation, it would be difficult without making more detailed distinctions. Considerations concerning the legal nature of the above-mentioned acts should be started with an assessment of their normative value. In this context, it can be noted that EPA are documents with different content. Prima facie, unlike typical normative acts, like, for example, statutes. They include provisions like indicative provisions, data information or forecasts, influential ones, encouraging the taking of specific actions, and the most important imperative ones, directly indicating the behavior of the generally defined addressees by establishing binding goals, tasks, values, and methods of acting with associated negative legal consequences if in case of failure to implement them. Referring to the imperative provisions, it should be assumed that all the EPA can be considered normative acts. This is, of course, dependent on the specific provisions adopted in the given act, which are shaped on the basis of relative freedom. Nevertheless, the statutes provide grounds for formulating a normative content of the analyzed documents, Polish statutes, of course. This conclusion includes the following elements of statutory regulation. 1. A clear indication that we are dealing with an act of local law. Second, introducing a requirement that a given planning act be consistent with another or included in another act. 3. Making the content of the administrative decision dependent on the provisions of the planning act. 4. Imperative to achieve goals, directions, or actions, the failure of which may cause negatively the legal effects. And 5. Clear authorization to formulate in the planning act obligations and limitations concerning specific entities, including those located outside the administrative apparatus. Given the nature of the addressees of the imperative provisions of EPA, these acts include both acts of universally binding law and acts binding only within the structure of public administration bodies. Constitutional determinants of EPA could be divided into systemic and competence determinants, substantive and procedural ones. Later, as I said, I'm going to focus on the first group, but the second group was discussed by me, in fact, at the May conference in Budapest, and the last one will only be signaled. EPA determines of a systemic and competence nature. First of all, it is worth considering whether the fundamental law indicates entities that should be assigned tasks and competences in the field of environmental protection implemented by means of planning acts. The answer is in that article, for me of course, 146 of the Constitution. It introduces the presumption of the competence of the Council of Ministers to conduct the policy of the state. This conducting is a complex process, but for me, undoubtedly, adopting by the Council of Ministers of Planning Acts, which are an expression of specific concepts in the field of identifying, weighing, and selecting significant values to be implemented, is an element of the process. The objective scope of the above policy covers all areas of social relations. In particular, the policy pursued by the Council of Ministers, including planning acts, relates to environmental protection. Furthermore, it is worth pointing out that Article 146 of the Constitution clearly empowers the Council of Ministers to ensure the security, internal and external, of the state. This concept includes inter alia ensuring ecological security for present and future generations, as stated in Article 74 of the Constitution. Therefore, this aspect of state policy should be of particular concern to the Council of Ministers and thus an important element of the planning acts adopted by the indicated body. In an opposition to such assignment, one can find the regulation of the Constitution according to which the local government participates in the exercise of public authority by performing a significant part of public tasks. In the analyzed context, this means the necessity to guarantee in statutes a significant scope of powers for local government bodies to adopt EPA. We are dealing with the implementation of this assumption on the basis of regulations concerning, for example, so-called voivodeship, powiat, and communal or municipal environmental protection programs, as well as air protection program or short-term action plan. These are the names from Polish statutes. All of them are the subject of resolution of local government bodies. Against the background of the statutes, a certain regularity can be seen that reflects the constitutional assumptions. These planning acts, which first are more of an implementation in nature in relation to environmental policy, second, provide for subjectively, objectively, and territorially specific values, goals, tasks, and measures. Third, result in orders or prohibitions, direct orders and prohibitions, directed at entities located outside the public administration system, are adopted by local government bodies. On the other hand, the sphere of general environmental planning, including generally defined values, goals, tasks, and measures, a general reference to the entire territory of the state, is of course the domain of the Council of Ministers and the minister responsible for the environment or climate, because we have those two spheres. Furthermore, the regulation of environmental planning acts presupposes that they include also the values of other spheres of social relations and their implementation at different levels of territorial division, for which different authorities are responsible, public authorities are responsible. These are the premises for making reference to the constitutional principle of cooperation between public powers. Compare the preamble of the Constitution. You have it on the slide. The forms of implementing this principle may be very diverse and include, in particular, the obligation of the authority adopting the Planning Act to consult its draft with other authorities or to seek their opinion. One of the obvious foundation of a democratic state ruled by law is the principle of legalism. Taking into account the nature of planning acts as normative acts, the constitutional determinant contained in Article 94 in conjunction with 87 of the Constitution should be indicated. Pursuant to this regulation, planning acts of local government bodies, including generally applicable legal norms, may be established only on the basis and within the limits of authorization contained in the statute, i.e. in an appropriate normative act of the Parliament. Some doubts, however, are raised by these authorizations, which do not clearly indicate the form of the Local Law Act, but require interpretation on the basis of the content and effects of the given planning act, i.e. on so-called material criterion. This applies in particular to environmental protection programs. It is not clear if they have internal or universally binding nature, and even if they are normative acts. But compare, for instance, Article 186 of EPL, so environmental protection law is the main statute for the environmental protection in Poland. This is the issue of the normative value of this act, environmental protection program. The limits of issuing acts of internal law are determined mainly by Article 93 of the Constitution. All these acts must comply with the requirements of this provision. The features of such an act include the following. 1. It may apply only to organizational units subordinate to the authority issuing the act. 2. May only be issued pursuant to a statute. 3. Is subject to control of compliance with generally applicable law. And 4. May not constitute the basis for decisions against citizens, legal persons, and other entities. These criteria give rise to some doubts in the light of the regulation concerning the Act of Environmental Planning. The relationship between these acts refers in particular to the relationship between, for example, Council of Minister and Voivodeship Parliament, or the Minister and Voivodeship Parliament, or the Voivodeship Parliament and the Commune Council. In these respects, there are prima facie links between entities independent of each other, between which there is no subordination in the meaning of Article 93 of the Constitution. Despite this, the legislator introduces competence norms, including a resolution of the Council of Ministers, such kind of competence like concerning a ministerial communique, or a resolution of the Voivodeship Parliament, without clearly indicating that it is an act of local law. The aforementioned acts may be addressed to the organs of local government units. So the entities outside the organizational subordination. The aforementioned acts, it excludes the relationship of subordination described in Article 93 of the Constitution. In this context, environmental planning acts affecting entities outside the circle of organizational units subordinate to the authority issuing a given act should be established, in my opinion, in the form of a generally binding normative act, i.e., instead of the given names, a regulation of the Council of Ministers, a ministerial regulation, or an act of local law. The legal literature, Polish literature, however, indicates the possibility of adopting a compromise solution, i.e. distinguishing the third category of sources of law, intermediate between generally and internal law, generally binding and internal law. It is referred to as sui generis sources of law, informal sources of law. Nevertheless, in my opinion, the distinguished concept contradicts the intentions of the authors of the Constitution, for whom the constitutional system of sources of law is dualistic and closed. The consequence of distinguishing environmental planning acts as normative acts is the necessity to refer to them the constitutional principle of hierarchical structure of the system of legal sources. One of its main consequences is, of course, the requirement that the norms contained in planning acts comply with the higher order norms, i.e. statutes, ratified international treaties, the law established by an international organization, the Constitution, of course, and in relation to internally binding acts, also with other acts of universally binding law. This rule might be problematic in the context of the statutory dependence of the Planning Act, an act of local law, example Air Protection Program, on the resolution of the Council of Ministers or on the communique of the minister responsible for climate. It means, indeed, a requirement that an act of universally binding law must conform to an act of internal law, which is inconsistent with the constitutional regulation. Okay, so I'm going to finish, yeah? Yes, of course. Okay, so the next one is the main issues concerning the other constitutional determinants, I mean substantive and of procedural nature, so you can read this. And the conclusions before my presentation are as follows. The Constitution provides for a general allocation of powers to issue EPA, I mean the Council of Ministers and local government. This is combined with the need for cooperation between the public powers. The fundamental law defines the requirements for the legal statutory basis of environmental planning acts. The Constitution formulates the requirement that the imperative provisions of EPA comply with the higher order norms, and the last two regulations raise doubts in the context of statutes when they require compliance with formally internal planning act by non-subordinated units or by generally binding acts. Thank you very much for your attention, and the partners, most important part. Thank you.